everyone. Thank you for everyone who's already joined. I think we're going to be starting in just a couple minutes here, right at 12 or at 1 p.m. So feel free to just hang out for the next couple of minutes.
Help me out. I'll give you this one right here.
Hi.
All right. Click on them. You're looking at that. All right. I'm not back by 3:30, John.
Come get you.
Make sure I'm alive up there.
All right.
All right. Well, it's looking like it's about 1 p.m. and I can't see everyone who has joined, but I might just give it one more minute to let people trickle in the next minute or two. So I think I'll just wait, maybe one more minute before I start. Thanks to everyone who joined so promptly. Okay, well, I think I'm going to go ahead and start. And if people come in a couple of minutes late, that is completely fine. We are recording this presentation just to let you all know, and we're going to be publishing it on our new fancy YouTube page after this. So if anyone wants to reference the presentation after this is done, you can go ahead and just access it there. So today's presentation is on public contracting, procurement, and contract types. My name is Ashleigh Dougill, and I'm a new associate attorney here at BEH. And just so you know, so I can see messages on occasion when I'm presenting, but I'll likely not be answering those during the course of the presentation. I'm hoping to leave some time for any questions that you may have at the end of the presentation. So just so you know, hopefully there will be time for that. So our goals for this presentation today is not for you to be an expert on the topic. We understand that this is a really complicated area of law. You know, there's a lot of statutes and rules associated, but we really want to give you the tools to be able to recognize issues that might arise in your work for various public agencies, and then ask for assistance or come to us with any questions that you might have. So here's just a bit of an overview on the topics that we'll be discussing today. There are, like I said, a number of other rules and regulations associated with public contracting, but we're just going to be focusing on procurement and contract types today. And we'll just be briefly mentioning a few related topics, but not going into a lot of detail on those, just because I think that they're important to keep in mind in the context of procurement. So just as a brief initial introduction, again, making sure everyone's on the same page, what is a contract? What are we talking about in this context? So there's no statutory definition. Oops, sorry about that. There we go. No statutory definition for a contract, but case law does establish three main elements, and that is first, an offer from one party, acceptance of that offer from another party, and then some sort of consideration to change hands. That can be money, that can be really any other type of consideration that you can think of. So for example, let's say that a private company approaches you, a city official, and offers to sell you a work vehicle. You accept this offer, you say, this sounds like a good idea, and I will pay you $1,000 for that work vehicle. Now, technically, you have a binding contract, even though nothing has changed hands, nothing is written down. Technically, if one of those parties wanted to go and enforce that contract, they could do so. So it's really important to remember you can have a contract even if nothing's in writing. And sometimes if you have something in writing, it's not necessarily a contract. So there's lots of different forms and items that can qualify. If you are agreeing to something of value on your agency's behalf, we just really recommend you to pause and consider whether what you're really entering into might be a binding contract and therefore might be subject to public contracting rules and public procurement requirements and other rules and regulations. So where do local authority or where do local entities get their authority to enter into contracts? So ORS, that's state statute 279A, establishes local governing bodies as local contract review boards. This just means that local governing bodies have the ability to enter into contracts, negotiate contracts, etc. And most often they appoint their local contract review boards as their governing body, such as like their city council for a city. Then further, that local contract review board can delegate or subdelegate portions of their authority to members of that entity. So for example, again, in a city, it might be common to delegate some of that contracting authority to the city manager, allow the city manager to sign some contracts on the city's behalf or negotiate certain contracts below a certain dollar threshold. A lot of these rules for local agencies can be found in local contracting rules, and these are often based off of what's called the Attorney General Model Rules. This is basically just a big body of rules that can be found in the Oregon Administrative Rules, Chapter 137, and then Divisions 46, 47, 48, and 49. So you'll sometimes see local contracting rules that simply say, we adopt by reference the Attorney General model rules. What that means is it just means we're just going to follow the OARs 137, 46 through 49. But on occasion, a local authority might want to get a little bit more sophisticated or a little bit more complicated with it and add some additional restrictions or regulations to their local contracting ability, maybe different dollar thresholds, maybe other obligations, et cetera. And in those cases, it's really important to check your local contracting rules. So this presentation is just going to be focusing on the Attorney General model rules and also the Oregon revised statutes. But it is important to just keep in mind how those might interplay with your own local contracting rules and to contact your local attorney if you have any questions about that. So even if something might be considered a contract, it might still be accepted from the state contracting rules and regulations. There is a really long, detailed list of exceptions to the public contracting rules, but I'm just listing here the ones that I see as like most common. If a contract is accepted from the public contracting rules, that means that you don't have to follow public procurement for it. You don't have to follow those Oregon statute requirements or the Oregon administrative rule requirements. Some of these exceptions include intergovernmental contracts or interagency contracts, insurance contracts, grants, property acquisitions, or debt issuance, loan, financial investment contracts. So all of those don't have to follow the regular procurement process and they don't have to follow the administrative rules. So before we get into the meat of the actual presentation, like I mentioned, I just want to briefly touch on 3 topics that are related to procurement, but don't necessarily fit into the rest of the presentation. But I think they're just kind of important to keep in mind in this context. And if anyone is interested on these, then potentially as a future presentation, I could go into, or someone else on our team could go into them in more detail. These are Q&As, cooperative procurements, and just prevailing wage. So Q&As are qualified nonprofit agencies. There is a big statutory definition for these, but basically it just boils down to a nonprofit organization that is validly organized, not operated for profit, complies with state and federal health and safety standards, and produces goods and services, and with which it employs individuals with disabilities for at least 60% of work hours or labor that's required to produce those goods or services, or another federally established standard. So basically, it is companies that produce goods or services while employing people with disabilities. And the Department of Administrative Services keeps a list of all the goods and services that are available from Q&As. And for public entities, they're required to purchase goods and services from a Q&A at the price that the DAS establishes, if those goods and services are listed, if they meet your specifications, and they're available when you need it. There are some limited exceptions and different rules when there are multiple Q&As who qualify and are available. But again, we're just not getting into that level of detail for this presentation. I just wanted to mention them as a concept briefly. Another item that I want to touch on briefly is the concept of cooperative procurement. So this is a procurement that is conducted on behalf of one or more governmental body. So this allows a contracting agency to kind of piggyback on certain contracts that are already in place with other contracting agencies. And this can be really helpful if, for example, maybe you want to get a bulk price for certain goods or services and you can cooperate with another entity that already has a contract in place, or even another state that might have a different price. There are a lot of different rules, regulations, exceptions, and contexts in which you can and can't use this though. So again, just mentioning this as a concept, and if you would like further information on cooperative procurement as a method, feel free to contact us. And then just a really, really brief note on prevailing wage, because I can't do a public contracting presentation without just mentioning that prevailing wage exists. But prevailing wage rates are amounts that must be paid to construction workers on all federally or state recognized public works projects that use funds of a public agency in Oregon. These are either state through state statute or what's called the federal version of that, which is the Davis-Bacon Act. And this is a really complicated area. It's really fact specific and often is just decided on it depends on the facts of the individual case. So I could do a whole separate presentation on prevailing wage. And just wanted to briefly mention it because it is a key component in many public works projects. And yeah, just something that's important to keep in mind for public contracting. All right, so the meat of the actual presentation, procurements. I'm going to be talking about a few different types of contracts today, starting out with goods and services, the category of goods and services. So generally, you can get the authority for this if you're ever interested from the state statutes or ORS Chapter 279B. That covers all the goods and services, and the corresponding administrative rules is Division 47. And goods and services is most government contracts. So what are they? So goods are really what you think they are. It's just tangible things. So it is, you know, it can be supplies, equipment, materials, personal property, and then any of the rights that are inside of those, so like IP and other stuff. So this could be cars, it could be police equipment, water pipes, office computers, you know, raw materials, all of those can be goods. And then in contrast, rather than property, services can be acts or deeds or deliverables that people provide for you. That could be, for example, IT support services, landscaping services, janitorial work, and you know, the list goes on. You can imagine all the different types of services that are available. But it's important for this part of the presentation, services do not include personal services. Those are more specialized services, and I'll talk about those later in the presentation. This is more those like day-to-day services, such as landscaping, janitorial work, etc. So for goods and services, there are 4 main types of source selection that is available for you as an agency. You can use competitive bidding, competitive proposals, intermediate procurements, and small procurements. So competitive bidding, this is the first one that's available. This is most often used for large amounts of goods or when you're purchasing goods in general. When you think, I want the lowest price for this, that's when you want to use competitive bidding. A competitive bid requires what's called an invitation to bid or an ITB. And there's specific requirements for these in the statutes and the model rules. Again, like I said, an advantage of an ITB is that it focuses on the dollar value, and this kind of fosters a competition among the bidders, right? They want to give you the lowest bid. You ultimately award the contract here to what's called the lowest responsible bidder. So ultimately, it does need to go to the lowest price, but there is a little bit of flexibility in that definition of responsible there. So a responsible bidder has to follow all the public contracting requirements. It has to meet standards of responsibility that are set forth elsewhere, and they couldn't have been disbarred or disqualified otherwise. And there's a little bit of flexibility there for agencies to put in what certain qualifications for what makes a responsible bidder. You can look at their previous experience on similar producing similar equipment. You can look at whether they've seen bankruptcy in the last couple of years, et cetera, right? So there's a little bit of room in that word responsible, but mostly this is focusing on the lowest bid. And there are notice requirements and public inspection requirements, just like with most things in the public sector, identified with competitive bidding. But that can be important to some private entities that aren't used to working with public entities to consider. So then the next type of procurement is competitive proposals. So these are most often used in the goods and services context for services procurement. And this is this is the situation where you're not just looking at the price and a little wiggle room besides the price. You want to have a more holistic approach to the entity that you want to hire. You want to look at, work experience. You want to look at their expertise. You want to look at their experience working on this type of particular project or in these certain circumstances. That's when you want to go with an RFP. So again, for a competitive proposal, that requires an RFP. And again, there's specific requirements for this in statute and model rules, just like with the ITB. Like I was mentioning, there's more flexibility and discretion here in the process and the award itself. It allows more room for negotiation. And again, ultimately, price is not the only factor. Sometimes even it is a minimal factor. You want to look at the expertise, work history, and more. And again, just like the ITB, there's public notice and special public inspection requirements associated with RFPs. All right, so other than RFPs and ITBs, there are lesser restrictive requirements when a good or a service is worth less than $150,000. So if you believe that a good or a service is going to be worth between $10,000 and $150,000, then this can qualify for an intermediate procurement. You can always go ahead and use the ITB or RFP process if you really want to, but these ones, technically, you can use the less formal process if you would like. So intermediate procurements, you have to seek, the keyword there is seek, you don't actually have to receive, seek 3 informally solicited quotes or proposals. As long as you keep a written record of your efforts to receive 3 quotes or proposals, then whatever you receive is fine. You could receive less than 3, and that's completely fine as long as you kept a record. Ultimately, you award to the company that will best serve your agency's interest. So in that, pricing is a factor, but it's not the only consideration. And here, it's not the as strict, notice requirement. So notice of intent to award isn't required here. And then finally, you have small procurements. So this is anything that is less than 10,000. And ultimately, this is in the agency's discretion. So it can be awarded in any manner that the contracting agency deems practical or convenient. And often this is just a direct award, direct appointment to whoever you choose. Something that's really important to keep in mind for both small and intermediate procurements is that you cannot artificially divide a project in order to qualify it for a small or intermediate procurement. So let's say you want to hire someone for a service. You can't break up the deliverables of that service. One deliverable is going to be 80,000, one deliverable is going to be 80,000. Now both of them qualify for intermediate procurements. That is not, unfortunately, how it works. You have to lump those all together. It's a total of 160,000, and therefore you have to go through the more formal process. Also, if you reassess your good or service and you determine that it's actually worth more than you originally thought, you need to reassess the procurement method and go with potentially a different procurement method. You can't just stay with your original procurement method necessarily. And then finally, it's important to just remember that local contracting rules are a thing. And so there might be different, more strict requirements or different even monetary thresholds on a local level than these ones that I listed here. And other than those 4 main ones that I just mentioned, there are a couple other less common, but also used procurement methods. And these include sole source, emergency procurements, and special procurements. Again, these are less common, but we just recommend if you want to hear more about these or to use one of these, we just recommend you contacting your local attorney. So with most public processes, there is an ability for the public to protest, and that's true for public contracting as well. So state law allows protests of any exemptions, solicitation terms, and also contract awards. and a protester has to exhaust all their local remedies before they're able to go to court. And often those local remedies are set forth in your local contracting rules. So if you see, there probably are local deadlines for how quickly someone can protest, et cetera. And I just encourage you to check your local contracting rules for that. But ultimately, if it does go to court, judicial review is generally governed by a writ of review process. So that means that it is on the record and subject to a substantial evidence standard. All right. So within that category of services, there's a subcategory of personal services. So these are the ones that I was referring to that are more of the expertise services. However, there's really a lot of room for county or for public agencies to define personal service themselves. You can designate whatever you want basically as a personal service within certain confines under your local contracting rules. And you can also specify what procurement methods you want in your local contracting rules. However, if you don't have that in your local contracting rules, then the same rules, the 279C or B series, the same ones that apply to services applies here, and also the 279C only in certain contexts, which I'll cover later. So again, those are for the specialized services. So here's just like some example language from a client of ours of how they define personal services themselves. They said it's specialized, technical, creative, professional, or communication skills or talents, unique and specialized knowledge, or the exercise of discretionary judgment skills, and for which the quality of the service depends on attributes that are unique to the service provider. So again, that's it emphasizes that it needs to be, discretionary judgment, professional or expertise of some sort. And then they use some examples as, attorneys, accounting and auditing services, IT services, planning development services, and more. So yeah, that's just an example of some personal service language. So moving on to another subcategory of professional services. These are those ones that are in 279C. The legislature decided that these professional services in particular needed to be laid out in state statute for whatever reason. They think that these ones needed the procedure for these particular ones to just be very clear and set forth. And it's important to remember, it's a really limited list of services here. And if the service does not fall into this list, then 279C this aspect of 279C does not apply. So this is just a very limited list, though these services are very common, especially in public works projects or just projects for construction and design services. So these services specifically are architectural, engineering, photogrammetric mapping, transportation planning, land surveying services, and then a category called related services. And related services is defined, but it basically just boils down to services that are related to this list. And so for these special types of services, which I just refer to as construction-related professional services, because they're mostly design services or services that are related to construction, the agency is expected to select and negotiate a contract with the most qualified consultant, and this is called a qualifications-based selection. So up until 2019, there was a bit of a different process for this, but now in recent law, you now are allowed to include pricing as part of screening in the selection process. That used to not be the case. Now, however, you can, so long as you include other additional information in your RFP, and this includes, you have to include a cost estimate. Some entities, for one reason or another, are not comfortable with including a cost estimate when they're seeking a construction-related professional service. If you choose not to include a cost estimate, then you cannot consider the cost until after you have determined who is the most qualified. And that was the traditional approach before 2019. So There are some exceptions to qualifications-based selection. Agencies can directly appoint if there's an emergency, if the contract value is less than 100,000, or if the contractor has previously performed work that is related to the same project that you're hiring them for. And again, these are another place just to keep in mind, things might be different on a local level. There might be different dollar thresholds, et cetera. So these are just the state requirements. You can also get an exemption from the QBS process or from any other process under state law. Anytime you deviate from any requirement under the statutes and it does not qualify for an exception, you have to get an exemption. So this is the process for getting an exemption. The agency must draft findings that consider 13 different categories of information. So those are all listed out in statute, but they include things like the budget and financial data for the project's technical complexity, any specialized expertise that might be involved, and et cetera, et cetera. And all of those findings need to show that if you grant that exemption, that it's unlikely to encourage favoritism, and it's likely to result in substantial cost savings or other benefits. So all of those findings should be trying to prove those 2 points. And then it also must follow statutory notice and hearing requirements. It needs to be presented to your local contractor review board. Ultimately, your review board will either approve or deny it. And if it's approved, then it may be ultimately appealed. Then for construction-related professional services, there's also either a formal or informal selection process. So informal is anything that is expected to not exceed 250,000, whereas formal is 250,000 and above. For informals, you need to create an RFP with express selection criteria requirements. Then you need to provide that RFP to at least 5 prospective contractors and negotiate with the highest ranked proposer. If it's a formal process, then you must either create an RFP or create a request for qualifications, which will be followed by an RFP, and then this will have specific selection criteria, public advertisement notice, et cetera, all included in the RFP. It's a bit more formal. You also need to promote an evaluation committee, and this evaluation committee reviews your RFP, scores it, ranks the proposals, et cetera, and then ultimately negotiates with the highest ranked proposer. And again, just like all the other processes, it is subject to public protest. Prospective contractors can protest the contents of the solicitation documents and contract award. And the protester has to claim that it has been adversely affected or aggrieved in order to have a claim. The contracting agency also must resolve any protests within a reasonable time with a written decision. All right, so this is the final category of contracts that I'm referring to in this presentation. So these are public improvements. So public improvements for this definition, I just usually think construction services. So the one that I just talked about are the construction related services. This is the actual construction. So the definition in state law is a project that's for construction, reconstruction, or major renovation on real property by or for a contracting agency. So again, to me, the keywords there for all of you is the construction, reconstruction, and major renovation. So even if something fits into that definition, though, it is not considered a public improvement if no funds of a public agency were used, if it is a work that is considered an emergency or in the context of an emergency, if it is only minor alterations to that public improvement, or just ordinary repair and maintenance. None of those are considered an actual public improvement. And even if something falls into one of these exceptions, it's possible that it's still subject to public contracting laws. So we still encourage you to contact an attorney or consider those other contexts. All right, so for public improvements, Oregon follows the least cost policy as far as its procurement method goes. And this means that you must solicit public improvement contracts through an invitation to bid and award it to the lowest responsible bidder. And this is the same process that I already went over for invitations to bid. So there are some exceptions for following that process, following the invitation to bid, lowest responsible bidder. Contracts with Q&A, you don't have to do that. Any contract that's exempt, or any intermediate or small procurement. If you are seeking an exemption, it's the same process that I laid out for construction-related services, which is where you get the 13 different categories of the findings that prove that the exemption is unlikely to encourage favoritism and likely to result in substantial cost savings. So the intermediate and small procurements for public improvements have similar requirements as the goods and services intermediate and small procurements. However, it's important to note that the dollar thresholds are different. So for an intermediate procurement, for a public improvement, the dollar threshold is $10,000 to $100,000, which is lower. However, like the goods and services, you must use, unlike the goods and services, you must use the competitive quote process, but like the goods and services, you must seek at least 3 competitive quotes, award to the company that best serves the agency's interest, and notice of intent to award is not required. And then small procurements are any contract less than 10,000, and it's in your discretion on how to appoint those. So finally, now that I've laid out the different procurement methods and the different contracts that are available, when you are delivering a project as a whole, that is probably going to involve a few different contracts throughout the life of the project. There are different delivery methods that are available when you are doing this, and different considerations when you're doing that in the context of public procurement and public contracting. The traditional method, or the design bid build a method, is where an agency contracts separately for design and construction services. So in this method, they first contact a designer or an engineer and get a design for a project. Then you take that design and you bid it out to available construction workers, who again will respond to your invitation to bid with the lowest responsive bidder, and then take that design and build it to spec. That is the traditional approach. However, in more recent years, there have been alternative contracting methods that have become more common. There's a whole variety of alternative contracting methods, but 2 of the most common are construction manager general contractor, or CMGC, and design build, or DB. So for the construction manager general contractor, the agency procures professional services on a qualifications or best value basis from a construction manager during the design phase to offer suggestions on innovations, cost and schedule savings, and identify constructability issues. Then, upon completion of design or individual design packages, the contractor and the agency will negotiate a price for the construction contract. And then the construction manager acts as a general contractor to complete the construction. The contract can employ a GMP guaranteed maximum price administered on various bases, just depending on negotiations. And then the agency will contract with the designer and construction manager at the same time. And this encourages there to be collaboration between the two and input from both. This can ultimately result in a more cost-effective and better design because you have both working together. The construction manager is then responsible for contracting the general contractor upon design completion. And again, that's that middle diagram there. And then finally, the other more common method is the design build method. And that is where the agency contracts with just one entity to complete the design and construction for a project under one single contract. So this is typically a lump sum with allowances or unit cost items to address risk. And in this case, there is more of a risk on the design builder, whereas in the CMGC approach, the risk is kind of throughout all of the parties, that's distributed more equally throughout the parties. Because the risk is all on the design builder, often the price can get pretty complicated, and you can see a higher price potentially. But it has been implemented using various procurement approaches, including qualified low bid and best value. And again, the key there is that all the design and construction duties are only held by one party. So both these methods are just meant to save time and transfer design and other risks from the owner to the design builder or the CMGC. And both methods are pretty complex and require you to get an exemption, go through that exemption process that I talked about with the 13 different categories of findings, et cetera. So agencies are wise to only use these if they have experienced personnel in the topics or if they're working with an attorney. And yes, that is my presentation. I appreciate you all listening, and I know it was a lot of information, so I tried to save some time for any comments or questions that you may have. I'm going to stop screen sharing, and that way I can see any comments that might be added to the presentation. Let's see. There we go.
Ashleigh, I have a question. This is Sue at Can Be Utility.
Yeah.
When do you, I'm really confused about when you would use an RFQ versus an RFP.
Yeah, that's a great question. I didn't really get into RFQs in too much detail for this presentation. An RFQ is not a process of determining, of getting an ultimate bidder or proposer. It's more of getting, if you have potentially a lot of entities that might be available, or you're really trying to whittle down a lot of different candidates for a specific role, an RFQ is a request for qualifications. So it allows you to kind of narrow that pool and get a more specific and a more qualified pool of candidates that then you can present your RFP or your ITB to. Does that make sense?
It does, but what types of things would you need an RFQ for? Is that basically back to the engineer, photogrammetist, surveyors? Is that where you would use an RFQ?
That's a great question. It might be in a lot of different categories. Let's say you wanted a skate park to be constructed, but you know that there are 50 construction companies in your area who have skate park construction experience. You might use an RFQ to specify some certain qualifications that you want for the people who are going to respond to your RFP. Then you will send out that request for proposal, or you'll send out that request for qualifications. You'll get those responses, and then for the ones who are the most qualified, you then will provide your RFP to those individuals rather than having to do the entire RFP process for all the 50 qualified individuals.
Okay. The other question I have is, so if we buy transformers, that's a good, and we've got our 150,000 intermediate procurements, basically getting 3 bids. But say the transformer, say there's each transformer is $1,000. And if you need 20 transformers, that puts it over the 100,000. The individual transformer is $1,000. But when you total them all together, say it ends up being over 200,000, how do we work on that? Because the prices of everything have gone like skyrocketed.
Yeah.
Where we used to buy something for say $1,000, now is like $2,000 or $3,000.
Yeah, that's a really common issue, I think, for public entities, right? Prices are crazy right now. And that's why I was saying it's really important to keep in mind that the prices of things might go up. And in that context, it might put you in a different bracket. So something that might used to have been an intermediate procurement might now come across the threshold of needing a full ITB or a full RFP. So if you're buying something, if you're buying multiple items, multiple goods from one entity and it's all under one contract, you can't artificially divide that. So again, I mean, this is just a general comment, right? Not specific to that question, but yeah, you can't artificially divide a project. So it would probably end up qualifying for the higher, like official RFP or ITB.
Thank you.
No problem.
I have a question about the segregation of contracts and dividing them up artificially.
Yeah.
So say you have a service that you do, it's something you're going to probably be doing forever, right?
Okay.
How do you partition it? Is it each year? Because, theoretically, if you do it forever and ever, right, you have an infinite contract, which no. So but if you partition it by a year, it falls into a different category.
That's a great question. That's a really good question. So most of the situations that we see where it's ongoing services, this is not always the case, but most situations where it's ongoing services, it is a personal service. So again, that's that subcategory of services that require the additional level of expertise, right? And in those situations, there's totally different procurement requirements typically. So
what if it was something like a subscription service? Maybe it's 90,000 a year, right?
Yes.
It's not a personal service unless the contracting agency makes it one, right?
Well, it depending on the subscription, it probably is a personal service. So for example, IT, that's a common one. That's a personal service. A lot of those subscription ones can be personal services and often are designated as such in your local public contracting rules. Not always. And if it isn't, if it's just an indefinite term of a contract, that can have other issues
Right.
that your attorney probably would want to talk to you about, in addition to the procurement. But yeah, I think I would want to see what kind of service it is. Is it a personal service or is it just that more general category of services? Two, is the term actually indefinite? If it is, then maybe we want to try to renegotiate that contract. And then
I guess my question is more, how do you, if you're going out for an RFP or something, do you cut it up each year and then say it renews?
no, you look at the
thing that goes on forever.
Well, hopefully it has a definite term in some capacity, even if it's a really long term, but you want to try to estimate the value of the services. So if it's a term of 20 years and it's $3,000 a year, that's going to be 3 times 20 for the value of the contract.
But what if you get to pick the term?
Well, then it's probably still has an end date.
Yeah, I guess what I mean is the intersection of those two things, artificially segmenting and the term. If it's a service that essentially the city is going to use forever, if you cut it up each year, it's not, you don't have to do the more complicated, you can just do the informal bids.
So are you imagining a situation where you hired a consultant, but you only signed a term, one year contract, and then you kept extending the contract?
Or what would be, I guess, am I artificially segmenting it if it's something that essentially we're going to do forever? Like, it seems like I'm always artificially segmenting it.
I think when I say artificial segmentation, I'm meaning more where the value is what is over the limit, and then you purposefully try to divide the services or purchase it at different times of the year so that it's 2 different contracts, or some other method to purposefully avoid that dollar threshold, if that makes sense.
Okay, yeah, that does make sense.
Anyone else have any questions? I can't see if anyone has their hands raised, so feel free to just speak up, unmute yourself.
I have a question. So public improvement contracts, I understand the difference between that and construction related professional services. But if you're doing something like a design build, it's both. Because, you know, design builder, they're doing the engineering or architecture or whatever it is and doing the construction. So is that still considered a public improvement contract?
That's a great question. So that is why you have to get an exemption to be able to use those alternate delivery methods, is because it doesn't really fit into those traditional categories that I was talking about. So when you do a design build, you're going to one general contractor entity that's going to be your one-stop shop for everything. And they're going to likely be subcontracting out a lot of the work. They likely don't have the ability to design it all themselves and construct it all themselves, but you are hiring them to be responsible for that work. So what it usually looks like is a segmented contract where certain public terms apply to the design aspect and certain public terms apply to the construction aspect. But the actual procurement of those services is usually a little bit more complicated RFP because you're probably more interested in other aspects besides just the pure price.
Okay, thank you.
Yeah, I see Rebecca has her hand up, and then I also to chat. So I'll take Rebecca, you first.
Hi, this is Jenny with City of Sandy. I'm with Rebecca. My question was, I think that $10,000 and $150,000 limit for the intermediate and small procurements has been the same dollar amount for many years now, and certainly doesn't account for the inflation that's occurred for, say, the past 7 to 10 years. Is there any movement on state, on these regulations to actually right-size this? So I don't know, those are more reflective because they're just diminishing values that we can purchase, and they're forcing us to go through more administrative hoops.
I mean, I completely personally agree. I think it would be great if we could reassess those values. We all know how things move on a state level. So I'm not sure if anything is, if there's any movement on that, in recent times. But I would love to see it as well. I know it's difficult. It really is. It's difficult for cities to have that flexibility for sure, or just any public agencies. So I definitely feel that, but unfortunately, yeah, I'm not sure.
Okay.
And okay, I'm just going to answer. Let's see. Sue says, when you have a professional services contract with an electrical engineer, they are considered your engineer of record. How long can you continue the contract with your engineer of record before you find another engineer? That's more of a individual contract question. So that will just depend on the term in the contract itself. So I'm thinking of hopefully giving another presentation on essential elements of a contract. So once you've done this whole procurement process and you're actually contracting with your counterparty, what do you want to see? What are the essential things you want to see in every contract? Term is one of them. How long is this contract going to be in place? And if you control F in your contract for term, chances are you're going to be able to find that. Hopefully that answers your question. Okay, Nicholas, it looks like you have your hand up.
Yeah, I do. The legislature just passed this past year, and I'm trying to find the bill number, and I can't remember off the top of my head. They raised the prices. They raised the dollar thresholds for goods and services.
That's wonderful.
It's Senate Bill 1047. And it takes effect in January.
That is great to hear. I'm sure we'll be having an update on that. I know that we're in the works of drafting a whole legislative update to send out to our clients here shortly. So I'm sure that will be included.
I just wanted
and
to
I really appreciate you adding that, because yeah, that is very relevant and wonderful to hear. Okay, well, if no one else has any other questions, well, feel free to still speak up if you do, but otherwise, this meeting was recorded, so we will be posting that recording I said at the beginning on our new YouTube page. And we'll also be making the presentation available, I believe, for anybody who wants to have it or view it. I think Kristen, our legal assistant, said that that she can make it available for anyone who wants it. And then other than that, I have my email address on the last slide of the presentation. And then I also added another public contracting attorney in our office, his email address at the end as well. So if you have any follow-up questions about the presentation or, you know, your public entity's public contracting needs, feel free to reach out. Thank you all
Thank
very
you.
much.